My name is Inu Manak. I'm a senior fellow for international trade at the Council on Foreign Relations in Washington, D.C., and I work on U.S. trade policy and the law and politics of the World Trade Organization.
Great, welcome. Thank you for being here. So, first of all, I wanted to ask you, what should Canadian policymakers, business leaders, investors be looking out for in an eventual ruling from the Supreme Court on this case, particularly with regards to how it will affect things in Canada?
So the case before the Supreme Court regards the tariffs that have been put in place regarding the International Economic Emergency Powers Act. These are the IEEPA tariffs, as we often like to call them. In February of earlier this year, President Trump put these tariffs in place against Canada, Mexico, and China, claiming that fentanyl coming across the border was a threat to the United States that he needed to address with tariffs. So right now, those are being challenged in court. And what we're looking to see is whether or not the Supreme Court upholds the lower court rulings, which basically said that these tariffs are in fact illegal. And they're saying that these tariffs are in fact illegal because they violate the Constitution. They essentially reach too far in terms of what the president is allowed to do. If you look at the statute, the IEEPA law doesn't even say the word tariff in it. And so there's a big question about whether it authorizes the use of tariffs at all. So both lower courts have said this does not authorize tariffs, and now the Supreme Court is taking it up to make the final decision on that case.
Okay, thank you. Canada is obviously affected by the outcome of this case, given they're caught up in the trafficking related IEPA tariffs. And if those were to disappear, the White House has said they'd be replaced by the Liberation Day reciprocal tariffs baseline as well. However, the carve out for goods that comply with the United States-Mexico Canada agreement has so far been such a shield to the Canadian economy that really the greatest concern to many businesses and policymakers here in Canada are the sector specific Section 232 tariffs, which are not addressed by this case. So depending on the outcome, depending on this ruling, what should Canada be looking out for there in terms of any future relief from tariffs or where the president may head next?
Well, I think there are a few different ways that this could play out. So, on the one hand, we could have the Supreme Court essentially say, yes, the law does allow the president to use tariffs for the International Economic Emergency Powers Act, but perhaps not the tariffs that he put in place, not all of them, right? So, we could have, I can imagine, a limited ruling that says those reciprocal tariffs that were put on the rest of the world are not okay, but maybe the trafficking tariffs, because they deal more with a national security issue, are okay. In which case, Canada would still be covered by those tariffs. And then in addition to that, have these other tariffs in place on sort of sectoral areas that are of concern to Canada. We would have then essentially the status quo. Not much would change, and we're back to continuing the negotiations on creating exemptions to those sectoral tariffs that are also in place. Now, we could have a situation where these tariffs are basically ruled to be unconstitutional, in which case we no longer would have that IEPA tariffs. And as you mentioned, Canada's had an important exemption to this, that this CUSMA compliance that allows for a lot of the trade to still flow between our two countries. But in the case that these tariffs are vacated, we could imagine that President Trump will look to other laws to enact similar tariffs. And now, if we look at all the different statutes that are on the books, in fact, Congress has delegated a lot of different authorities to the president to raise tariffs for a variety of reasons. And he could go reach out to those laws in order to enact similar tariffs. Now, there may be some limits. Some laws only require up to 15% increases. Some have, a 50% increase. So there may be some bound constraints on what the president could do. But I would also imagine that he would ramp up his efforts on those Section 232 national security sectoral tariffs and have that expand to other sectors that would have a lot of product coverage that Canada would be concerned about.
Okay, thank you. And one thing I noted from your brief was on the Section 232 tariffs and how these investigations have been really moving quite quickly. It's been my sense that when one is announced, the conclusion is almost a foregone one, that an investigation means that tariffs are coming in one form or another, although not always exactly as expected, as we saw with the copper tariffs, right, where many of the key products were actually removed. So what's something that, in the context of this ruling, that we're expecting that Canadians should be looking out for there?
Well, we've already sort of seen this administration have a lot of action on the Section 232 front. Now, this is a law that essentially states that the president can take action to regulate the importation or exportation of different things to address national security concerns, right? So if there are imports coming in that he's concerned about that threaten to impair the national security, he could take some sort of action on that. Now, he has used that in a variety of ways. First was putting back online the steel and aluminum tariffs that he put in place in his first term. President Biden had maintained a lot of them or transformed them into quotas, or there were exemptions negotiated down in the CUSMA agreement as well for Canada and Mexico. And then he took action on autos and auto parts, and then copper, and the latest one was lumber. Now, there are many others that could potentially be created in the coming years. So I would imagine that on these 232s, what we're starting to see is a fairly expansive understanding of how the president could apply these tariffs. Now, when you imagine that you can apply a tariff for a national security purpose, you would essentially have to identify those items that are the actual concern, right? But what this president has done so far is to create a process by which not only the product that we're concerned about faces a tariff, but the derivative products. So that means things like an aluminum derivative, like a beer can, could be considered a national security threat according to the way that this administration has interpreted that law. So they have a list that is really, really large, and they've actually asked folks to bring in other items to add to these lists, an inclusion process, which is quite different than how we've seen Section 232 investigations and implementation work in the past. Typically, they have a list, and then you negotiate exclusions. And what we're seeing them do now is to build a list and ask companies to bring in more products to that list. And so we're seeing this sort of spread in other areas that we never really would imagine it would have spread to. So I think that 232 is really a fundamental a pillar in President Trump's trade strategy, and one he's going to continue for the next 3 years.
And what parameters are around those? Like, what limits are those? Because obviously a big theme of this this case that's going to the Supreme Court is presidential powers, and whether, one can decide upon a whim whether to impose such sweeping tariffs. In terms of the other laws, there are, of course, there's time limits, there's sometimes level limits, investigations are required. And yet we are still seeing these things happen so quickly. So I'm curious about your thoughts about, if the Supreme Court decides that the initial ones are unlawful, can we expect a different approach if other forms of tariffs are applied?
Well, the 232 tariffs are very sticky, and they're sticky because we've already seen a continuity from Trump's first term to today, right? And those tariffs on steel and aluminum were challenged in court. Those litigants lost their case. And what we saw unfold through both the Trump and Biden administrations was a delegation of authority, a deference to the president in deciding national security related measures when it comes to trade. And so those have largely gone untouched because of that. So I would imagine that any future court challenge on these Section 232 tariffs is going to face a real uphill battle, because the case law already basically says that the president can do what he wants in this space. Now, the statute provides some important guardrails. Number one, there's supposed to be an actual investigation, right? There's supposed to be an announcement of investigation. The Secretary of Commerce is supposed to collect information from interested stakeholders, have a report that's supposed to be issued that explains the link between the measure they're taking and the national security threat. And that process is supposed to take place over the course of over 180 days, right? Now, we haven't really seen that process play out. And what we've also seen is sort of a reversal of the process itself, in the sense that Secretary Lutnick is essentially saying what the remedy is. I'm going to apply tariffs on these things. He announced tariffs are coming. And then he does the investigation. Well, you can't decide the remedy until you figured out what the problem is. And so he's basically been stretching the procedural limits of this statute in a way that I think could potentially have a court challenge on its own on these procedural grounds. So that may be something that happens next year once we're settled on the IEPA decision itself. But I would also say the important thing to keep in mind about these Section 232 tariffs is that Congress created this law. And Congress actually has the authority to remove these tariffs if they wanted to. So that's the big guardrail that exists, but Congress has so far failed to act. Now, I would also imagine that if the cost of these tariffs continues to increase, if President Trump takes ever more national security actions and we start to really feel it in the US economy, Congress may be motivated to act because otherwise they're going to face a lot of pressure from their own constituents. So that's the one hope that Congress will intervene at some point. Otherwise, Congress has the power to rewrite this law and basically take away the president's authority to do this at all.
Okay, very interesting point. And I also wanted to ask you, in the event that these IEPA tariffs are upheld by the Supreme Court, on the one hand, something may not immediately change in Canada, but I'm also thinking about how, just as the IEPA tariffs were brought in through executive order and presidential power in this sweeping way, so was the exemption for USMCA compliant goods. So what should Canada be on the lookout for there in terms of it may be status quo, but it may say something about the future of the status quo. So I'm curious about your thoughts on that.
Yeah, I would say that if the IEPA tariffs are maintained, we're kind of going to be in this holding pattern for the next few years, right? Where President Trump decides to threaten more tariffs to get leverage for negotiations on a whole host of different topics, and that can come and go. The really crucial point, I think, for Canada at this moment is the fact that the CUSMA exemption is a critical component of maintaining a degree of stability amongst all the uncertainty that we're seeing today with regard to the tariffs. And the fact that we have this CUSMA review that's supposed to happen next year means that the focus really needs to shift to finding ways to preserve that agreement to the extent that can be preserved so that there is continued predictability in the trading relationship between the two partners. So this, I think, is a really major priority. But in addition to that, Canada also needs to figure out how to get those exemptions solidified with those sectoral 232 tariffs, because that's where it's going to hit quite hard. I think we're going to start seeing that on the lumber side. Certainly, there is concern in British Columbia. Recently, you've heard a lot of reports that there is concerns of how this will ripple through the industry. And these are concerns that need to be brought to Ottawa and then be the focus of the negotiation. So I think there's like a two-pronged strategy here. One is really to preserve the market access under USMCA and ensure that there's no higher tariff above that. And second, really to ensure that there are strategic carve-outs for those 232 tariffs, because at the end of the day, Canada is one of the United States' oldest allies, a trusted partner. They are not a national security threat to the United States, and I think the government needs to make that case.
Okay, thank you. That was great.